new to SheKnowsMoney. Can you tell us a
Not
little
at
bit
all.
about? Oh,
No,
nice. Nice to see
attending
you
quite
joining in. Yeah.
times.
Hi. So, are you excited for our session today?
Super, super, super.
Great. And where are you joining in from?
Delhi.
Great, great. Yes, the weather must be it must be hot there, right?
Yes and no both. God has been kind. It
Mm-hmm.
doesn't sound like May. Yeah.
Yeah, I can
We
tell you
still
Well,
have a
here.
long way to go.
I can tell you one thing about Steffi, like Mumbai cars, Delhiites are Delhiites. Whether it's hot or cold, we still love Delhi. I'm from Delhi.
Oh,
So
yes. Any day. Any day. Any day.
Yes.
Yes.
That is true, and I think that goes with Bombay also. Weather is crazy, but then yeah, we just flow with it. So yeah, I think we can. I mean, we can just wait for a few more minutes. Anything else? Anything in particular that you're looking forward to, Nupur, today?
No, when I just got the message, in fact, I had forgotten that we have this session today. And the
Mm-hmm.
most interesting thing which I noticed was wills and uh, your, what's that other word I'm forgetting? Mm,
Trusts and gifts, I think.
pardon?
Session planning and estate planning.
Trust. Okay, there's a C.
Is it
Yeah,
estate?
wills is important. Yes, I can hear you.
Right,
Yeah.
right, right. Yeah. So, how did you hear about us? Is it through Aspire for her?
Yes, I'm part of Aspire for Her.
Oh,
I'm one
nice.
of the mentors. Yeah, I'm part of
Steffi, you're
it.
asking,
Yeah.
yeah, Nupur is actually a very well-known mentor in Aspire for Her. So I was wondering why you're asking all these questions.
Yeah, I,
Thank you. Thank
Okay, you
you.
guys have
Yeah,
not
we
met.
haven't met. Yes, we haven't met.
Yeah, but Nupur is
but
well known in the AFH Trillion community.
Hey,
nice.
thank you. Yeah,
You know. Nice to
lovely.
meet with you today. Finally, that is.
Yeah,
Yeah.
same here, same here.
Yeah.
So I suggest, Steffi, let's get started. I
Sure.
think yeah.
Yes.
So I think, welcome to the session, Nupur, and everybody that is viewing our session today. For those of you that are new here, we usually get started with our icebreaker questions, which is then followed by our opening poll, after which I'll be handing it over to our speaker today, Aditi. So without further ado, I will request Tanvi to get started with the questions, please. Over to you, Tanvi.
Hi, a very good evening to everyone. So today topic is the fifth in the series, as Steffi already mentioned. And the first question that I have for you is that, are you guys aware of different tools that can be used for estate planning? Any clue of what are the different tools that we can use for estate planning? And you can use the chat box or maybe just unmute yourself to answer that question. Maybe a wild guess will also do.
Well, I've heard of them, but I am not aware of the depths of it, though.
Similarly, cheekily says that yellow is the only one I know of as a tool. Nobody also want to say something? Okay, so
Yeah.
I'm going to take that as a no from the audience, and maybe this is why we are doing this session, because Aditi can now throw enough light on what we actually have at our disposal to do the real estate planning. The next question is even more interesting. So do you think you should update your will from time to time? What views do you have on that? We all know that there's a will that we want to make at some point in our lives. Yes. Okay. So that was a huge resonating yes, Aditi, for you, which is a good thing if people know that we should be updating the will. And with these two ice-breaking questions, I will hand it over to you, Aditi, to take us through the entire journey of today's session.
So yeah, I think just a little before we can get started with the session, I will quickly launch the poll. Sorry, Aditi. But we just have to, 1 second. Farisha, would you be able to launch the poll? 1 second, I got it. Yeah. Okay, you can probably see it now on your screens. It says, do you think a will is needed even if you have a living trust? it's a very popular opinion that some people believe that you don't need both. So, okay, people say yes, it is. I don't see any responses for the no, which is great. I think we're all on the same page. Okay, 1, 2. But see, no wrong answers here, right? We're here to learn. Okay, I think we have majority of our responses. I can go ahead and the poll now. So now that we're done with the poll, I will quickly introduce Aditi. We have with us today Aditi Joshi, who is the head of legal affairs at Yellow. She will be taking us to the topic tools of estate planning. A very warm welcome to you, Aditi, and over to you. Very, very excited.
Thank you. Thank you so much. And it just feels amazing, being with you guys every month, meeting amazing women, taking out time from their daily hectic lives just to be a part of, to learn something new time and again. So thank you so much. And with that, we'll dive right into today's session. I'll just share my screen. You can confirm once you're able to see it.
Yeah, good to go. We can see your screen over here.
Okay, great. So today's topic is going to be about what are the different methods through which estate planning can be done. It's very funny because the moment whenever I meet someone, I talk about estate planning, they usually understand that I'm talking about real estate.
Real estate.
Estate planning has as a whole, it talks about how your legacy is to pass on to the next generation and doesn't have to do anything with your planning of the real estate. So we'll cover today why nomination is important, part of the whole estate planning scenario. We'll talk about a will, we'll talk about the tool of a trust, we'll talk about gifts, and we'll also talk about some joint properties and the right of survivorship. Essentially, today's goal is to make you understand the various options that are available. It's important to understand which of these tools suit your specific scenario, and then accordingly, you should, so to say, plan the succession of your estate. A quick recap always helps because these figures remind us how important it is to write a will. In India today, 150,000 crores of assets are lying unclaimed. This is the data published by the Lok Sabha. The reason behind this unclaimed amount is one, people don't write a will so that, people don't know really whether that asset even exists. To give you an example, how many of us know, what bank do our parents really deal with, or bank account numbers, or those little fixed deposits here and there that our parents have done? And unfortunately, once the person is not there anymore, they're just lost in transition. And hence, unfortunately, we have this pool of 150,000 crores. And this is hard-earned money, corporate India, your and mine, white hard-earned money. Unfortunately, 76% of the disputes in India that are plagued, the courts are because of property. And all this can be sorted out if we just take things in our own hands. And if we make sure that we've put enough, steps in place so that our legal heirs don't need to fight for what we own. Also, if you're lucky, 3 years it takes approximately for the entire estate planning process, especially the asset transfer process, to take place. This is if you're lucky. Of course, if there's a court dispute, then we've seen enough movies to kind of show that it can just go on for years and years. So this is essentially what the estate planning wheel looks like. I'll touch upon each of these tools as we go along. However, it's important to understand that the will portion of this particular wheel is the most important and the most fundamental one. The reason being, A will comes into effect only once the person is not there anymore. All the other tools are steps that you take during the lifetime of a person. But because you own assets, just because you write a will, you will still have control over your assets. So, for example, even if, again, don't get bogged down by the technical jargons, I'll distill it down for you as we go along. But let's say you create a trust in your life, or let's say you sign a gift deed. Those properties stop being yours. For example, if I gift a watch to Nupur today, the watch is not mine anymore. It belongs to Nupur. But if I write in my will that once I'm not there anymore, my watch will go to Nupur, the ownership of the watch remains with me. So I can change it as many times. If I feel today, no, I think Nupur has enough watches, I think I should give something to Steffi, I can change it as many times as possible. So these are the tools which are available. And like I said, I'll delve into each of these so then we understand its importance. Nomination is again very important in the asset transfer context. But let me explain what really is a nominee. If you see the very first column where I've written nominee is equal to trustee, what this means is, let's say you go to a bank and you open a bank account. Now, let's say you ask, the bank guy, you've given me some form to fill up a nominee. What is the role of a nominee? The bank guy will tell you, oh, don't worry, your nominee will get everything once you are not there anymore. He's only partially right. Essentially, the role of a nominee is that of a trustee, which means the nominee is to receive the asset only to pass it on to the actual legal heirs which are there. I'll give you a very simple example. Situation 1, let's say I have a bank account with HDFC Bank. I have made my sister as the nominee. Now, in the event I'm not there anymore, my sister can receive the money, but she has to pass it on to my husband and children, who as per law are the rightful heirs. My sister is not the rightful heirs. Who decides these rightful heirs? Our personal laws. So there's a separate law for Hindus, there's a separate law for Muslim, there's a separate law for Parsi, for Christians, etc. So those personal laws determine. Situation number 2. Let's say I know that my HDFC bank account, I want my husband to receive the proceeds in the event I'm not there. Instead of making my sister, I'll simply make my husband as a nominee so that the asset transfer process becomes smooth. Let's say if my husband and my sister does not get along, then it'll be tough for my husband to claim the asset for my sister. So what you should ideally do is synchronize your beneficiaries in the will and then accordingly appoint or update your nominee. Is my example clear, or I'm happy to elaborate if there are any queries?
I have a question.
Yes, Nupur, please.
Because I'm a mother. So all my accounts have a nominee. My daughter is a nominee. So will the same thing apply on her? Like once in my absence, does everything automatically go to her, or what is the law?
So I'm assuming you're a Hindu?
Yes, very much.
Okay.
Yeah,
okay.
Very much.
So for a Hindu female, the husband and the children become equally entitled to the asset. So in that case, your bank account proceeds, your husband and your daughter, they have equal rights on that particular asset.
What if I don't put, if I've only put my daughter's name then?
So in this particular case, no, so your daughter can receive the asset. And then in that case, ideally, she's supposed to distribute the proceeds between all the heirs which are there.
She's my only heir. Yeah.
Yeah. Now, to give you another example, this is, of course, if you've not left behind a will. Now, if you write a will, you can mention that proceeds from, let's say, HDFC bank account will go to my daughter. In that case, only your daughter becomes entitled to that money.
Okay.
That is why writing a will becomes important, because you can choose who can receive the assets, and the law does not decide who your beneficiaries should be. So if you see the very first column, in these situations, the nominee is only, for example, a custodian or a caretaker of that asset, only to then pass it on to, whether it has to go via will or without will. See, essentially, there are only two routes through which the inheritance take place. One is with a will, that is called testamentary succession, or without a will, that is intestate succession. Now, the very first column is a general rule of nomination. In all these cases, the nominee is a trustee. But our laws are not as simple as we would like them to be. So if you see the second column, for these 4 asset classes only, the nominee is the ultimate beneficiary. So even if I mention in my will that for my insurance policy, let's say my husband should get everything, but if I've made my daughter or my son as a nominee, then the nominee becomes the beneficiary. So ideally, what we generally recommend is whoever you want them to be the ultimate beneficiary, rather whoever you want should reap the benefits of your assets, you must appoint that particular person as a nominee. So essentially, again, the asset transfer process becomes very smooth, because that's our ultimate goal, right? Like to make sure that there's a smooth transfer of assets from one generation to another. And a nomination can play a very big role in that. So we'll move on to the next one. Will. Now again, a will is a most humble document and the most easy to make. Simply, you can write your wishes on a white paper. You, of course, need to be 18. You need to be capable of understanding your actions, obviously. And you should sign your will. In India today, only wet signatures are permitted. You cannot digitally sign your will. So you should sign your will, have 2 additional witnesses, or, see you sign that particular document. The witnesses also have to imprint their signatures, and then that becomes a valid will. So it's super easy. You just need like total 3 signatures and you're done. Now let's understand what is the importance of having this will in place. So like I said, is the most basic and fundamental part of an estate plan. So whether you write a will, whether you have a gift, whether you have a trust, you need to have a will and all the other instruments surround that particular will. See, essentially, like I said, I will need some amount of money for my upkeep till the time I'm around, right? So that is why we need to have a will. So all those assets which you have retained for your upkeep are important. And then you can mention those in your will. Like I mentioned, it helps you to surpass or bypass your personal laws which apply. We have Hindu Succession Act for Hindus, Indian Succession Act for Christians. We've got the Muslim laws depending on which sect you belong to. So there are different personal laws which govern us. And when we write a will, we can, help keep those aside, and we can choose who our assets can go to. Now, when you don't write a will, asset transfer becomes much more tougher, because let's say if you go to a mutual fund house, or if you go to your bank account, or you go to any other place where your asset is, the body which takes care of your asset, they will ask you to produce a number of documents. Example, succession certificate, or in some parts of India, it's called as family tree or pedinama. And like I mentioned, laws in India are complicated. So every state will have its own different variation. So, for example, in Mumbai, in Madras, and in Calcutta, we have something called as a probate. So that is needed in these three places. In other places, you don't need probate, but there are different requirements. So that's why asset transfer becomes very difficult if you don't have a will, because you'll have to again go to court. You'll have to apply saying that, look, these are the legal heirs, and now that property is to pass on so and so. Why do banks or mutual fund houses ask for this? Because how will they know who is the rightful heir? Now, again, if you have a nominee, then this becomes simpler. But again, nominee and a will is a perfect combination. Moving on to the next point, we've seen earlier, 1,50,000 crores of assets. So naturally, asset discovery gets lost in the whole process. And when you have a will, you should consider your will as an asset register. This means that you should write down that these are my assets and these should pass on in so and so fashion. Now you'd wonder, but what if I write that my HDFC bank account has 5 lakh rupees? How will I safeguard that? But to be very honest, you don't need to mention the numbers. You only need to mention enough details that can help you identify the asset. That is important. You can mention the bank name, the branch, the last 4 digits of the bank account number. Enough for identification. In fact, we recommend that you should not put amounts, because amounts will keep changing from time to time. So it doesn't really help you either ways. Next is, it obviously prevents property disputes. People think that if I write a will, then my family may be upset with me. But that's not true, because when you don't have a will in place, the family does not have a clear sense of direction. At least when you have a will, they'll know what is it that you truly wanted, rather than the heirs fighting amongst each other. Will becomes important if there are minor children involved, because today, as per law, the father is the first guardian and then is the mother. A will is one of the only instruments through which the law specifies that you can appoint a guardian for your minor children. I've mentioned this earlier in my previous session, but I'll reiterate. In COVID, we have seen young parents passing away in quick succession, and either side of grandparents are fighting for the custody of the child. Now tell me, who would know it better than you? Who's more equipped and capable to take care of your child in the event, unfortunately, if things were to go wrong? So you can appoint a guardian for your minor children through a will. And lastly, it gives you the power of choice. Let's say you have a nephew or a niece who has a musical parent of mine, and you want to pass on a beautiful piano that you have to that particular person, rather than, let's say, your own children not really understanding the value of what you own. Or let's say you came across an institution doing some really good work for the cause of animals, and you want to leave a small portion of whatever you own to them. All those aspects can be taken care of in your will, in the absence of which, like I've mentioned, the law decides who the legal heirs are. Now, some tips and tricks on how to make a good will. See, only making a will is not enough. Again, I'll give you an example. We had a client who came to us and asking us to just take a look at his will. And we saw the will was very simple. It mentioned all my assets to go to my wife. And after my wife is not their children. But then imagine the nightmare that the family has to go through to locate those assets. What is the bank account number? Was there a policy or not? Was there any bonds that the person had purchased? None of these were mentioned. So making a good will is equally important. So one is, of course, I mentioned 18 years of age, sound mind. This is very important, that mention the assets very clearly. If let's say you have a house in Chennai, mention the name of the society, mention the name of the flat, because this will really help for the identification purpose, rather than just saying my house in Chennai to go to so and so, or my land in Karnataka to go to so and so. Good to mention all those aspects. Get your will, like I mentioned, signed by 2 witnesses. And of course, you're supposed to sign the will as well. Appoint an executor. Executor is a person who's in charge of a couple of things when it comes to the person who's not around. One is, of course, to make sure that all your wishes that are mentioned in the will are properly carried out. Secondly, what executor is also supposed to file the returns, because let's say if a person has passed away in the middle of the year, file returns, closing of PAN card, application of death certificate, etc., etc. Interestingly, the law does not require for you to compulsorily appoint an executor, but we've seen enough cases where an executor has not been specified in the will, and when family is not really ready to take up a responsibility, let's say a particular family member is not ready, again they need to go to court to appoint this particular executor. So it's a huge hassle. So it's good to mention somebody as the executor. We would prefer to even have a backup executor, because what if your current executor doesn't have the bandwidth, or let's say they've moved outside India, then it becomes hard to do all the operational aspects here. So make sure you also appoint a backup executor. Now, these are the must-haves. Now, some tips that we want to share with what we've gathered in our experience. Video record the execution part of the will. The witnesses don't need to know what is mentioned in the will. You don't need to have like a Jeffrey Archer sort of a dramatic will reading session that we've come across. All you need to do is just make sure that the signing part is captured. So just in case tomorrow somebody has to challenge your will, they know that the will was made out of free will and you did it out of choice. Get a doctor's certificate which will state that you were of a good physical and mental state at the time of execution. For any will dealing with immovable property, we recommend you to get it registered because in the asset transfer process, we need to deal with the municipal corporation, etc. So they always rely more on a registered will. So it's good to get your will registered as well. We'll pause here to take some questions. Any questions anyone has?
Y'all can unmute or even put it in the chat box. We have a cozy small cohort today, so make use of it, I guess. Okay.
There's a question from Girija, and she asks, can a beneficiary be an executor?
Sure, Girija, a beneficiary can be an executor as well. There is no prohibition in law. Generally, to be very honest, it's usually the family members that themselves choose and pick an executor. So, to give you an example, let's say there's a family of 4, mother, father, and let's say, 2 major sons, then generally they prefer, obviously, and it's practical to appoint either the mother if she's in a position to handle it, or the children as the executor to do all the, take care of all the execution related aspects. So it's perfectly fine if the beneficiary and the executor are the same person.
I think we can wrap up, Aditi, if there are no questions.
Okay, now what is a trust? Essentially, a trust is more like a contract in which, let's say if I want to make a trust, I will appoint somebody as a trustee. Let's say I appoint Indu and Steffi as a trustee to take care of my property so that the property can reach the beneficiaries as and when I want. This is the primary difference between a will and a trust. In a will, there's no interim holding of that property. So if I mention that if I'm not there anymore, my watch has to go to Steffi. The moment I'm not around, the watch will go to Steffi. But if I'm making a trust, I can mention, it will be a contract between, let's say me, Steffi, Indu, where I mention that, look, Indu, Steffi, you hold this particular watch of mine and you please give it to, let's say, my brother or sister when they reach the age of 30. So you'll also see in the diagram which depicts this, the trustee holds the property in the interim period for the benefit of beneficiaries. Now, when does a trust structure become suitable? We'll just explore. Firstly, a trust is important if you want to immediately pass on the asset to someone. See, even when you write a will, there will be some buffer period when the assets will reach the beneficiaries. Again, I'll give you an example. Let's say in the event I'm not there anymore, I leave behind a will saying everything will go to my husband. But still my husband will have to approach the various authorities so that the asset transfer can take place. Of course, if a will is there, that will be smoother. Let's say it takes whatever, let's say 2 weeks for the asset transfer to take place. But he will have to wait for the 2 weeks. To give you another example, I make a trust. Indu and Steffi are my trustees and I tell them when I'm not there anymore, the very next day you give 5 lakh rupees to my husband. They already have that money with them because I've transferred assets, my assets into the trust so that they can accordingly manage whatever instructions I have given them. At the same time, in a trust, even while I am around, I can make those provisions. For example, again, if I make a trust today, I can tell Indu and Steffi, after 2 years, you start making these distributions to my family members. Every month, they should receive 10,000 rupees. So essentially, you can manage your affairs as per the directions that you have given. Now, again, what are the specific scenarios in which this is helpful? One, if you want to make staggered payments to your beneficiaries, this is very popular. Let's say if a family has some substantial wealth and, the children are too young. Now, in any given scenario, when a young child inherits too much money, it may not be the most ideal scenario for that particular person to inherit so much. This is very commonly we've seen where business families have made sure that their children reach a certain age where they assume that they'll be in a better position to understand the value of what they've received, and hence staggered payments can be made. For example, on 25th birthday, they should receive X amount, or let's say after that, if they go to college, the fees should be taken care of by the trust, etc. Trusts also become important, especially if there's a family member with special needs, because again, in that case, the trustees can make sure that the particular child or the particular family member is taken care of. It's very easy to actually challenge a will, because to be very honest, like any document in India or perhaps in the world, you have the right to challenge it. So there can be, certain circumstances which may lead to conflicts. But in a trust, the chances of conflict are very less Because the trust becomes operational while you are around. For example, again, if let's say, we sign a trust deed, again, me, Steffi, Indu, we sign a trust deed. From that moment onwards, I start planning my succession. Every year, let's say I put in some assets into the trust and I give instructions to Steffi and Indu to take care of those assets accordingly. So now, can the beneficiary under the trust challenge that, this person made a trust was out of, let's say, fraud or there's external pressure? No, because I was doing it while I was around. So that is an additional advantage. Also, in some cases, especially in some countries in the world, there's something called as estate duty. What this means is that when a person passes away, there are some death taxes which apply. So a trust can be a good option to plan estate duty implications. US has it, UK has it, Canada has it, Singapore has it, Japan has it. Usually the developed nations have it. Essentially, it's to bridge the economic disparity between the haves and the not so haves. So estate duty planning can be one additional advantage of such a structure. So this is a comparison that we've drawn, which will give you a better understanding. So the will, of course, we mentioned that it becomes operative only on the person's death, but a trust can be start functioning once the trust document is signed. Probate is a very good example that, again, we can bypass the whole process of probate and other asset transfers when it comes to a trust. Of course, like I mentioned, a will has its own advantages too. And to be very honest, even if you have a trust, you will need a will, because I will not put everything in the trust while I'm alive. I will retain some assets in my control so that I'm taken care of. Not that I don't trust Indu and Steffi enough, but still it's prudent to have your own assets in your own control so that you're taken care of. Incapacity, yes, a trust can be a better choice. Conditional bequests, or as we mentioned, staggered payments, you can choose the conditions under which your family members can enjoy the asset. It's very hard to challenge a trust, and I mentioned it's comparatively easier to challenge a will. But then again, if you take all the other steps that you've done, videography, you've made sure there's a family doctor certificate, all those things add to the robustness of a will. Will is obviously much a simpler process and also cost effective. Trust is definitely more complex, and it's also more expensive than a will. And under a will, you can't do estate duty planning, but a trust you can manage depending on the kind of structuring that you do. Any questions so far? And I hope I've not been too technical. I'd love to answer any questions if you have on a trust before we move on to the gift part.
Guys, you can type something in the chat box or unmute yourselves if you have questions.
Hi, this is Archana here. I don't know if you've covered this already because I missed some part of your session. Generally, people ask, even if you have a will, a succession certificate. How important is that? And is that really needed, or is just somebody doing it to be over cautious?
All right. Thank you for your question. So let's understand, to be very honest, if a will is in place, you don't need a succession certificate. Succession certificate essentially is popular when there is no will in place. To give you an example, let's say in Bangalore, you have to apply for a succession certificate if a person has passed away without a will, only with respect to movable assets. So for the immovable property, you need to obtain something called as a family tree certificate. So again, to be very honest, if you have a will, you should definitely, you don't need a succession certificate at all.
Okay, thank you.
Yeah.
Are there any more questions? I think we can move on, Aditi.
So, thanks, Sindhu. Gift, I know this is something which is again very popular, and you would have heard of it, especially in India, when a lot of gifts are given at the time of marriage. And those gifts are not just your regular household items, but there's jewelry, there's land. And income tax specifically provides that any gifts on the occasion of marriage are exempt from any taxation. Having said that, let's understand what is the essence of a gift. A gift simply means, let's say if I gift my watch to Indu, Indu becomes the owner of that particular watch. I stop being the owner. I don't have control over that watch anymore. Watch is a very simple example, but this you can extend to real estate and every other kind of asset. Now, essentially, we don't recommend gifting all your assets for the simple reason that you need to retain some amount of your own assets for your own upkeep. And we have a very interesting case to share with you on this. Firstly, you would have all heard of the Raymond family. So Mr. Vijaypad Singhania had gifted a chunk of his assets to his son, only to realize that he's not that taken care of as he wished. He tried to challenge the documents, but the court did not hold it good. Now, to all the principles of gifts which are there, we have a law called as the Maintenance and Welfare of Parents and Senior Citizens Act. This particular law prescribes that if a parent is gifting something to the child with the expectation and anticipation that the child will take care of their parents, in that case, the gift deed should specifically mention that they will take care of you, by virtue of this particular law. And after that, if your child does not take care of you, you can actually declare that gift as void. Or you can revoke that gift saying that I'll take back my property because I'm not taken care of. There have been many cases where parents, on a basis of an understanding, have gifted something to their children, but when they're not taken care of in their old age, like I mentioned, enough cases are there where parents have gone ahead to declare that gift null and void, but because that condition was not mentioned, that the child needs to take care of you, unfortunately, nothing much could be done. So that's why, especially, if you know somebody who's in this situation, you must talk to them about their rights, that they should specifically mention in the gift deed that they should take care of their parents. Now, this is the last part of the tools that we've covered today. Joint holding, again, is very common mode of estate planning. We must remember two important principles. One is, if you have anything which mentions a survivor, that is a right of survivor, simply meaning that, let's say 4 people hold, let's say, a property or a bank account together, and the documents specifically say that if one of the 4 is not there, the other 3 have a right to enjoy that particular property. This is called as a right of survivorship. So your, again, succession planning becomes simpler when you have joint holding. Very commonly used in India is husband-wife holding a joint account. But they don't realize that, let's say one person passes away, the other can rather enjoy the property. But what about after that person is not there anymore? So you need to plan the whole succession in such a way that end to end you've taken care of the rights. Now, what happens when there are two people holding property together, but there is no survivorship right? In that case, let's say if two husband wife are holding the property together, and it's not mentioned that there's a right of survivorship, let's say the husband is not there, his particular share, the 50% share, will be distributed between the wife and the children. And the other 50% can continue to be held by the wife. The disadvantage of this is the asset holding becomes too complicated in terms of ownership, especially if there are more people and you don't have right of survivorship. Let's say, in our parents' generation, 4 brothers holding the property together. Now, what happens when one is not there? So this is essentially what has led to fragmentation of land and, of course, family disputes. So we must be very careful as to how we're holding it. But definitely, joint holding of bank accounts especially is a good way to plan your asset. Any questions so far?
There's one question from Bibi Fatima.
Yeah.
She was asking, is it a way for big people to use trust as a way to evade taxes?
Okay. So essentially, to be very honest, if you look at a trust, there are broadly two categories or types of trusts in India. We have a private trust and we have a public trust. A public trust, so you see all those charitable organizations, they are public trusts. Now, to be very honest, yes, we've read enough that these public trusts, can be used to evade tax, etc. But what we're talking about today is a private trust. It's called as private family trust. What is the essential difference between the two? Is that in a public trust, you can't ascertain who the beneficiaries are. See, again, give you a very simple example. Let's say I open a charitable trust for upliftment of women. I have named a category. I have not named that these 10 women I will take care of. So you can't really ascertain who the beneficiary will be. But in a private trust, you can. So in that sense, it's very hard to use a private trust model to evade tax because your beneficiaries are very certain. For example, if I write a private trust, again, I'll make Indu and Steffi as a trustee. And let's say I mention that my husband and children and my sister and my brother will be the beneficiary. So I exactly know who the beneficiaries are. So in that case, the tax evasion part is very tricky. So it will not be in case of a private family trust.
Thanks, Aditi. Are there any more questions? Does a will supersede a joint account holder?
Okay. So essentially, to be very honest, a will can talk about the joint account holding, but essentially it's the joint account holder who will have the right of survivorship. But what your will can talk about is my share in the so-and-so, just in case, let's say you're not sure about what is the nature of your holding. In that case, you can mention in your will that my share of so-and-so will pass on to XYZ person. But essentially, the moment in the joint holding, when one person is not there, is a survivor who has access to all the right.
Guys, you can unmute yourselves if you have any more questions.
This is the time, guys. Shoot your questions and let Aditi know.
Okay, I have a question.
Yes, Nupur.
Yeah. A joint property owned by 3 people, okay, like an aunt and a nephew, right? Joint property. Now, if there is no will, it's mutual understanding. So, what happens if these 2 old people leave without will? Or even if they leave a will which the nephew is not, he has access to, or he is aware, what happens to that property then?
Actually, your voice is breaking a little. Is it just me or?
No, I also couldn't hear you very clearly.
I just heard that there's aunt and there's a nephew who's.
Is it clear now? Is it better? Is it
No, I can still hear the
There is disturbance.
disturbance.
Maybe you
Breaking
can
off.
just type it in the chat, Nupur.
Yeah,
Okay,
maybe
I'll
you
do
could
that.
just type.
So Aditi, there's one more question from a LinkedIn platform.
Yeah.
Achila asks that can mother-in-law transfer property as a gift deed to daughter-in-law?
So actually that will depend on which particular state that the property is situated, because see, they can definitely transfer. There is no embargo in transferring, but there are more efficient stamp duty wise. There are more efficient ways in which that can happen. So definitely, if the answer is simply that a mother-in-law can gift a daughter-in-law, the answer is yes. But again, from a gift deed and stamp duty perspective, it requests you to just check the law in which your property is situated, because accordingly there'll be implications.
So you're saying state laws also differ for that?
Yes, for stamp duty perspective.
Okay, thank you. I think that should answer Achila's question. Thanks.
Yeah. Because to give you a simple example, let's say, if a person is to gift something in Chennai, maximum stamp duty, in your relatives, they've defined family members. So in your relatives, the maximum stamp duty is 10,000 rupees. But if you do it to a non-family member, it's almost like 7% of the market value. So those implications come in. Otherwise, there's no embargo. You can do it any which ways.
I'm going to read out Nupur's question. A joint property owned by two aunts and a nephew. If the aunt passes away without a will, what happens to the property as it is on mutual understanding?
Okay, so Nupur, essentially, it becomes important to assess, like, on what basis is this mutual understanding taking place? Is it just oral? Because if one person passes away, if the aunt passes away without any will, then all the legal heirs of the aunt will have, a right in that property. Now, if your question is, if people can mutually decide that, okay, look, the aunt's children will not have any right, then in that case, there's something called as a family settlement that people enter into to then just chalk out their relationship. Okay.
Well, I hope that answered your question.
Sure.
Are there any more? I think that's it, Aditi, from this session.
One last question, coming in from LinkedIn again. So I think Neetu Kapoor asks, is it mandatory for will to be registered?
No, the law does not specify that your will has to be registered. However, it's recommended, if you want to get it registered, to add like an additional level of protection. Registration is not costly at all. For example, in Bangalore, it's for 5,000-6,000 rupees. I think in Bombay, it's for 7,000 rupees. It's not that expensive, but we recommend you to get it registered.
Okay, great. Thanks.
Yeah, any more questions, guys? If not, I will go ahead and launch our closing poll. Okay, I don't see any questions, so I will launch our closing poll. Okay, you can see the poll on your screen. So it says, do you think the session has helped you gain an understanding of the various tools available for estate planning and its appropriate use case? Okay, looks like we have a resounding yes, which is good news always. I'll have the poll on for another minute if anybody is yet to. Okay, I think I can go ahead and end the poll. Great. So now that we're at the end of our session today, I would like to take a minute to thank Aditi and Team Yellow for this truly wonderful session. It's always a pleasure having you do this with us. And today was a small group, but I really hope we all learned something new today. And that is all thanks to you, Aditi. So do follow us on all our socials, that is Instagram, LinkedIn, and keep yourselves updated on our upcoming sessions. Our next session will be on April 27th on the topic of primer on inflation. Once again, thank you all for tuning in today and see you all for the next session.
Thank you.
Thank you. Thank you so much.
Thank you guys. Bye.
Thanks. Bye.